everyone. Welcome to the session on the rise of AI and algorithms in performance management and recruitment. This is the second session of 2021 from the Jus Laboris Data and Privacy Expert Group, and there's one later in the year on European fines and enforcement judgments that we're going to look at, and then another one later in the year, which we'll update you on as and when. I am just going to start sharing my screen right now, so if you could bear with me for a second. I've got a small slideshow. There we go. The wrong slide. Oh, there we go. So, today, those of you who have attended the speed dating sessions before know that the whole idea is to give you a little bit of law, but also give you some colour from various jurisdictions. So today I'm really delighted to be joined by Jose from Spain, Soren from Denmark, Jessica from Germany, Marco from Italy, and Anastasia from Russia. I'll let each of them introduce themselves as and when they start speaking. But today we're going to cover just a brief intro from me about what we're talking about. Then we're going to have the first sort of speed dating session just about any interesting cases in those jurisdictions so that you can get a feel for how those jurisdictions are approaching this issue. Then I'm going to talk very briefly about the law from a European perspective, which obviously applies to Italy, Denmark, Spain and Germany. And Anastasia is going to give a bit of Russian colour there because there are some nuances. And I think sometimes in Europe, we get a little bit obsessed by GDPR and forget there may be other regimes around the world that look at things in a slightly different way. Then Jessica and Jose are going to talk to us about Works Council matters and their approach to AI and so on, which obviously with the Spanish and German bent have a very different perspective to, for instance, the Danish or United Kingdom perspective. And then we're going to try to end with some future horizon scanning, which will be no doubt highly disinteresting, uninteresting from me. But Soren is going to take us through some of the elements in the new proposed European Union AI regulation. And Marco is going to finish it off with some interesting thoughts of his own about the future of use of AI in the workplace. Annie mentioned, please do put your questions in the Q&A. We'll try to get to them. I have to say, I have so many screens that I now don't know where the Q&A is. But when we do have some time at the end to do a Q&A, I'll pick them up and I'll try and pick up as many of those as I can. And we'll obviously do some follow-up as well if we can't answer any of the questions. So just as a little intro, you'll see I put on the slide there something from the UK's Trade Union Congress from the summer of 2020. Trade Union Congress is sort of a federation of all the unions in the United Kingdom. Probably not all of the unions, but all the major unions. And they launched a survey of the ways in which UK employers are using AI in the workplace and automated decision making and all the similar kind of technology that we're going to talk about today. And you'll see there, this is obviously from a trade union perspective, so it will have its own perspective. But they say artificial intelligence is transforming the way we work and alongside boosting productivity offers an opportunity to improve working lives. Fantastic, very positive. I think we all agree with that. But new technologies also pose risks, more inequality and discrimination, unsafe working conditions, and unhealthy blurring of boundaries between home and work. Now, whilst I don't always agree with what trade unions say, I think you'll see today that as we bring out some of the legal issues and risks, that is not an outrageous statement from them. There are risks here, both in the discrimination paradigm and in general data protection and privacy areas. There are 3 reports that you can see yourself. These slides will be shared, which you can click on. They are quite an interesting read. They do take you through how unions in the United Kingdom are viewing AI, and that might be relevant for your jurisdiction or not. So one of the key things, here, sorry, I forgot about this. Here, these are a couple of great, very useful findings from the report. They did a rather wide-ranging survey, and they found 22% of tech companies already are using AI for absence management, 15% for ratings, performance ratings, 14% for work allocation, 14% for timetabling shifts, and so on. So at the other side of the coin, only 28% of workers responded they're comfortable with technology being used to make decisions about people at work. And indeed, I've done a few seminars for Lewis Silkin's Future of Work Hub, where I've talked about not necessarily legal issues, but issues around trust and use of data. Because obviously, as we go through the session today, although you'll see there are some legal issues that are interesting and need to be worked through, ultimately, algorithms, use of algorithms and AI is not different in so many ways to other processing of personal data. There just seems to be this, I wonder how many times, someone joked with me actually that whenever I speak about AI, I always mention this, but I'll do it within the first few minutes. People are always worried about, Terminator 2-esque things happening, Skynet's going to appear and suddenly computers are going to control. That isn't actually the case. And I think part of the lack of trust from workers is lack of engagement from businesses, lack of transparency about what they're doing. Because I think if employers were more transparent about their use of technology, that 28% number, one would hope, would rise very significantly. So just, there's always some confusion about what is AI. Read this slide at your leisure. But it was obviously a phrase first coined by Professor John McCarthy in 1950. AI is the science and engineering of making intelligent machines. And I'll just leave it at that, because there's so many different ways that people think of AI and machine learning. And there isn't there isn't a clear definition really anywhere. In the UK, it's only found in one place in the Enterprise Act. Artificial intelligence means technology enabling the programming or training of a device. I won't carry on. The European Commission project proposal, which Soren is going to talk about, does have a definition. Artificial intelligence system means software that's developed with one or more of the techniques and approaches listed in Annex 1, i.e. machine learning, logic and knowledge-based statistical approaches, Bayesian estimation and so on. But honestly, this could encompass so many different things. AI and machine learning is probably being used in your organizations now, and you may not even know it. It is something that is in our all pervasive in our day-to-day lives, from language and speech recognition in Alexa to, certainly in the UK, facial recognition on police cars, number plate recognition, and so on. So what are we really talking about in terms of the workplace? Somewhere within this subset here of artificial intelligence, machine learning, and deep learning, which might as well just go through. Artificial intelligence is the catch-all framework. Machine learning, subset of AI, where mathematical rules and algorithms are designed for the purposes of analyzing data. And humans train machines to look at data sets and extrapolate various learnings through the use of those algorithms. Deep learning is the one that we hear a lot about, which I think is the one where people jump to conclusions and talk about robot apocalypses and so on. But machine learning is just a sort of subset of, deep learning is a subset of machine learning, where the computer itself can start understanding and learning from the data set. So it can, through different, as they say in the business, different neural networks, start actually teaching itself how to improve its own decision making and so on. So at the end of the day, however, even deep learning is still looking at data sets, looking at how algorithms apply to those data sets, and potentially doing tasks like facial recognition, voice control, and so on. And then, of course, potentially some data analysis. But how does this potentially apply in the workplace? And this is the kind of stuff that we're obviously going to talk about. AI-powered tools are being used in recruitment at all stages now, from sourcing and dicing and slicing candidates before they actually go into a proper interview process, to screening, even to interviewing candidates, to forming job offers based on a predictive model. The TUC report talks about CV scraping as being one of the most common uses of AI, whereby CVs are scanned for keywords, and then a decision is taken by that AI algorithm should that candidate proceed from CV stage, I guess, the human interview stage. Other examples are automated background checking, social media screening, all the way up to, slightly unusual, but we've seen it with some clients, AI-powered psychometric testing. Indeed, I have advised a client recently about use of such an AI-powered psychometric testing, where there is an algorithm assessing someone's answers and pumping out a score, and then a human will look at that score and there is an opportunity to challenge, but that's an example of AI. Very rare, although we'll see it more commonly, I think, in the future, the possible use of chatbots, possibly even chatbots carrying out initial interviews with candidates with very set questions, with very set algorithms to work out whether the answer is acceptable or not to proceed to the next level of interview. I must say I haven't seen any of those yet, and I'd be fascinated if anyone who's watching has seen them. But I mean, it might happen. And obviously, loads and loads of facial recognition technology. We advise on that every single week in terms of security at offices, speech recognition technology. On the performance side of things, it's as equally pervasive. You know, there are some analytics tools being deployed, certainly even more so over the last year, bearing in mind working from home, to look at automatically how much time an employee spends on certain websites, write emails, email response rates. There's also examples of AI being used to calculate bonuses and performance ratings and so on. We've also advised a lot on AI being used in the data loss prevention space, potentially in relation to technologies that look at language and can recognize, for instance, competitive ideation within emails. So if an email is written to from outside to outside the organization, talking about data theft or client lists, then that particular technology can pick up that's a data loss prevention or competition risk, and obviously other things can happen from that. So, as usual, an unlettered and rubbish introduction by me, but I think the key to understand is that AI is a hot topic. I mean, it's written about all the time in newspapers in the United Kingdom. And the purpose of today is not to give you an absolute expertise in everything. It's just to give you that mixture of legals and some colour from all these countries, so that you can broadly understand what's happening and apply that to obviously your businesses and the jurisdictions that you look after. So just to allow the speakers to prep for the first speed dating session, which will be Jose in a moment, I think Annie is going to put up a poll. Yes, here it is. Which it would be great if people can just answer over the next 25 seconds, and then we'll see what the results are. So first question, are you currently using AI in the workplace now? You might not have known that you were at the start of this call, but I hope you probably do now. And the second one, do you intend to use any systems utilizing AI in the next 12 to 18 months? I was trying to vote there, but I'm being told hosts and panelists can't vote, which is excellent. So what did we get? Okay, 50-50, 80-20. So that's interesting. I suspect that some people who may have responded with 50%, they don't use it. It might surprise you if you actually ask some of your IT and development people. I suspect there might be some things which do utilize AI. But most interestingly, there, a clear rise in the percentages that are potentially going to use AI in the next couple of months. I don't know, Annie, if I have to close that. I did, excellent. So without further ado, we're going to move on to the first speed dating session, which is what's happening around the world. We're going to run through each jurisdiction and we're going to talk about one or two interesting cases. And you'll see the different approaches from courts and regulators and employee bodies. We're going to start with Jose from Spain.
Hello, good afternoon to everyone. Well, obviously, this is a trend that is going to increase in the next months. Big companies such as Amazon, Google are using this for selecting, promoting, paying bonuses, and even carrying out dismissals, which is very scary. But I would like to draw the attention, Alex, to something that is breaking news in Spain. The Work Inspectorate has implemented AI as a powerful tool to fight against the fraud committed by employers in the employment relationship. This is absolutely a disruptive measure and will permit this automatized detection of labor infringements in a massive way. So what was being doing by human beings, by inspectors, is going to be replaced to a certain extent, let's say. To be honest, this is just a preliminary step. But we are going to face two cyber inspections that obviously must respect guarantees. We refer to GDPR principles, avoiding biases and being transparent with, for instance, using objective criteria when selecting companies that are going to be investigated. So here the debate referring to Article 22 of GDPR fixes limitation on the automatized treatment of personal data referred to individuals but not for companies. That's the issue. And although work inspector is a public authority, in Spain, a special sanctioning procedure is going to be developed and it's going to counterbalance this faculty by allowing companies to request audits in the source codes that are used by the inspectors, and also providing access to the systems to check the absence of arbitrary biases. This is just, as I say, this is just preliminary. The scope is obviously quite limited to, on the face of it, to temporary contracts, disability checks, check if companies are contributing as requested or as expected in the CVA, work permits, etc. That's to say, it includes all investigations which do not require a legal analysis of very complex scenarios. Obviously, this is going to improve efficiency and effectiveness of the inspection in a massive way, where the human beings inspectors didn't arrive. Now the AI system is going to cover, and obviously is going to bring a lot of I don't know if a lot of money, but many sanctions are going to be imposed for employers that commit fraud in this regard. And that's my comment.
So that's very, very interesting, because I wonder, this is a public authority utilizing AI, obviously in a workplace context. Will it therefore follow that it would be easier for a private enterprise to deploy AI and say, well, hang on a second, you're using that in the public space, can't we use it in our private space? Or do you think the Spanish authorities will just say, no, this is only for public authorities?
I think going to use, but the curious thing here is that so the state is not a step behind, so they are the same level. And what is really scary is that this is going to be used on an official manner. So how the rights are going to be preserved, as I was saying, in Article 22, when it only guarantees or protects individuals, but not companies. So maybe we have to have a second thought about how Article 22 is going to be interpreted in that sense, you know?
Okay, well, very interesting. And thank you for that. And we'll come back, obviously, to Jose later for commentary on some Works Council stuff with Jessica. We're actually going to Jessica now for a particular German case.
Hi, Alex. And hello, everyone. I don't have a German case yet. And my general feeling on artificial intelligence is that, as we sometimes see with similar matters of, I don't want to say creepy, but scary technologies, Germany is a bit more behind. We are very much upfront with regard to data protection, have been for decades. But similar to background checks or whistleblowing schemes, that there has been a reluctance for a certain period in the past. So we do not see quite as much artificial intelligence on the HR side. This is at least my impression. What I do see a lot is artificial intelligence being used in the productive system of clients, such as an enterprise resource planning system. This is, I think there's less of a hesitance by using state-of-the-art technology in those matters. And one of the reasons might be that everything which you, Alex, have listed just now would, like performance analytics tools, email response rates, monitoring, all of this would, of course, be subject to the co-determination, the need to get consent from the Works Council. So you cannot just go ahead and do this once you've done your analysis of if it is feasible according to Article 22 of the GDPR. Yeah.
Thanks, Jessica. I know you're going to talk about some co-determination issues a little bit later. Just one quick question before we move on to Marco. We've had this come up a few times in some of the speed dating, monitoring in Germany again is perhaps a little bit more, I won't say behind, just more reticent, more reluctant. It's a cultural thing then in Germany, is it, around just too much intrusion in any workplace space? Do you think that will change? Or?
I think that's absolutely true. I don't know if it is because of the political situation in the 20th century with Nazi Germany, and then again the DDR, the Eastern German system. So I would assume you're right. It is just something where Germans steer very clear of. So I often see a real reluctance and as you mentioned trust, Alex. So this is, I think, this is trust or mistrust, not just against the employer, but simply against what technology can do. And to give you an example, a client just had a printer installed. Yeah, and by now printers are so intelligent that the Works Council needs to be asked for consent for a printer. Yeah, so yeah, because they can monitor so many things, and this is what really is the reluctance in Germany, what I think.
Yeah, and I mean, obviously, we installed all that technology about monitoring how much you're printing and what you're printing in our own office at Lewis Silkin, and of course, no issue at all. It's just a standard run-of-the-mill thing. But thank you, Jessica. Very interesting. I'm coming to Marco now for I think one particular interesting Italian case.
Thanks, Alex, and thanks everyone. This is Marco Sideri from Milan. And yes, there is one case, but more than one case, there is one law, because in Italy we do have since 2015 a specific law which requires to inform workers and to a certain extent Works Council and or administrative authorities about the systems that the employer puts in place. And the point is that the idea is very clear. So we do have a principle of transparency, which even predates GDPR. So employer, you have to let them know what you have inside you in order to use it. And this was a very specific, which had a ton of interpretation, both from case law, criminal, employment, and data protection authority activity and decision. For example, the call centers were the focus of great attention, with some decision from the DPA and the labor inspector going as far as to say that basic system that everybody uses were unlawful. It was one hot July, and maybe hot at the role in the inspector issuing that general statement. But if you read it, it's just 2 pages. It basically says that any system that controls telephone calls, incoming telephone calls, is outlawed in Italy. Of course, that's not true. What I'm saying is there's a great attention to disclosure on how the system works. And once you do that, then you can use it. On the other end, it's very hard to get to the bottom of systems. So we have very few examples of actual policies that dig deep enough to be considered sufficient to give an idea. And we go back to the data protection as tick the box exercise, which is the exact opposite of the general direction we're going in. Then we have cases on platform economy, plenty of them, which have commented and indicted algorithms and the use of data made by algorithm. What we know for sure is that the Italian employers already have a burden to describe what they use and the data they store. This burden or this obligation, to be more technical, is yet to find a final case law definition, but it's there and it's coming. So, you know, we're waiting for it.
Thank you, Marco. That's very interesting. And I think, you know, with, I'm sorry, I was going to talk about this later, but with the advent of potentially the AI regulation where transparency is becoming even more and more and more important, I think that Italian model is something for people to watch. There do seem to be a lot of cases, indeed, Marco, you and I have been involved in a few, in relation to use of algorithms, and the level of scrutiny that they can come under is really quite interesting. I think it might be it will show what's going to happen going forward. I'm going to now come to Anastasia, who's going to give us, I think, a couple of cases in Russia.
Hi, Alex. Hi, everyone. So actually, in Russia, we don't have some specific requirements for using artificial intelligence by employers, but still this use must be within the frameworks of such laws as Russian Constitution, which protects privacy, Russian data protection law, and the labor code, in particular, anti-discrimination provisions of Russian labor code. So in fact, Russian employers do use artificial intelligence for example, monitoring employee behavior, monitoring employee location, for making various analytics and predictions regarding employee satisfaction with the salaries, benefits, and so on and so on. It is also used for purposes of automated selection of the candidates' CVs. So all these shall be complied with quite strict requirements regarding automated decision making in Russia, which prescribe that such decisions, if they have any legal consequences for individuals, so they can be made only subject to obtaining of written consent from such individuals. And without such written consent, making such decisions is not allowed at all. So this is the main challenge, and in practice, companies try, when they making such decisions, they try either to include some manual processing of data in order to avoid making it exclusively automated, or they try not to make these decisions at all. So this processing is used just as some analytic, but not processing for further decision making. And also we have requirements that data controller must inform individuals about their right to object any decision which can be made on the basis of such processing. And this is also a challenge, because if such information is obtained, certain negative consequences for employers may arise. And Russian regulator supports quite conservative approach with this respect, and according to them, even analytics which is positive for employees, for example, satisfaction analytic with respect to the salaries, which can lead to normally to raise of the salaries, it is regarded as automated decision making, which is prohibited without employee consent. So it's quite restrictive in Russia. At the same time, we do not have much court practice, and all these restrictions, they are just guided by the regulator. So it means that companies still can try to form this practice and maybe make it more flexible in the nearest future.
Thanks very much, Anastasia. We're going to hear a little bit more from you later about some of the nuances of Russian law as well. I'm just going to give you a couple of cases, one from the UK, one from Ireland, before we come on to the Danish position with Soren. Very quickly, Bridges, we have quite a lot of cases on AI, as does tend to be the way in the UK. There's always a lot of cases on everything. Bridges versus South Wales Police. Court of Appeal actually overturned the South Wales Police, a challenge that South Wales had given to a High Court decision where they were prevented from using automatic facial recognition. And the Court of Appeal broadly upheld 3 grounds of challenge: that the South Wales Police hadn't given any clear guidance about how this AFR would be used. Similarly, that their data protection impact assessment was deficient, and that the police force didn't take reasonable steps to make sure that the software they were using didn't have any racial or gender biases, something we'll come on to later. And this was an AFR technology that would be deployed to look at crowds, and it would look at 50 faces per second, and then it would match them against crime watch lists, people with outstanding warrants and so on. What's fascinating about this decision, Mr. Bridges is a civil liberties campaigner of some stripe. It was lauded as AFR is banned in Britain, but that couldn't be further from the truth in terms of the decision. The decision was South Wales Police hadn't done an appropriate DPIA, they hadn't corrected biases, and they hadn't given guidance about how it was going to be used. So if they would have corrected that, then actually AFR would have been perfectly allowed, even though that is quite intrusive. Obviously, you could be in the crowd, police are there, 10,000 people in a football crowd, boom, 50 faces a second. That is quite an intrusive thing that can happen, but that's quite a typical example of how the UK courts look at it. There's no outright ban, there's no worries about it. You've just got to make sure that it's proportionate, you're transparent, and so on. Second one, which is in Ireland, which actually gives a different view. The Irish DPC, the Data Protection Commission, very much frowns upon the use of, for instance, biometrics. And in fact, there's a couple of recent examples in the education and prison service sector. In one case involving a prison, the prison had actually already agreed with the employee union that they could use thumbprint access for access to various parts of the prison, i.e. use of biometrics. And one employee complained to the DPC, and the DP said, no, you don't have a lawful basis, so they couldn't do that. So we are going to talk about lawful basis in a second and how hard special data and lawful basis is in the biometric space. But that's quite interesting that the employees were accepting of that through the union, but the DPC still said no. And similar, we've had similar cases in education. So that is quite a remarkable case in my mind, that even though when you get total employee buy-in, the DPC stepped in and said, no, you can't do this. So Soren, I think there's a similar biometric-esque case in Denmark, which you're going to talk about right now.
Yes, that's correct, Alex. Actually, we have two quite similar cases in Denmark regarding the use of fingerprints in employment matters. The one was a company where they actually also had agreed with employees that they wanted to introduce fingerprints for access of the building and also for registering working hours. And they then asked the Danish Data Protection Agency whether or not that would be allowed. And in short, the Danish Data Protection Agency said, well, the use of fingerprints, that's biometric data, and it is not necessary to use biometric data in order to establish when the employees came and left, what the working hours are. And in this regard, I mean, it's Article 9, and we will not allow you to use consent either from the employees, even though they think it's a good idea, because you can collect the same data using an access card with a PIN code, like we've been used to. So they turned it down, so they weren't allowed to. We then have another case, which is quite interesting, because in that matter, it was actually allowed. And that was a Danish food, in the food industry, you had a company saying, well, we need to register the employees being present at the factory and also being present in the specific production at what times. And we have to do that due to food concern, safety concern, and due to regulation in the countries we are exporting to. And we can only be positive who's been in the facility if we use fingerprinting. We won't even allow the use of ID cards with PIN code, because that could essentially be stolen or whatever. And even though that argument is probably a little short, the Danish Data Protection Agency actually said, well, in this regard, you had that's also because then you had the Danish Data Protection Act. They had a legal basis under that because it came from a collective bargaining agreement. So they had a legal basis of processing the special category of data, even though it was fingerprints. And then the Danish Data Protection Agency, they only could look at it from an Article 5 standpoint. And they said, well, in light of the food safety concern, in light of the concerns with you being able to export to other countries, we cannot say that this is not proportionate or this is not necessary. So we won't issue any criticism and we'll allow it. But obviously, that was a very fact-specific case where the first case is the general point in Denmark that you cannot use biometric data if other data will fulfill the purpose.
That's it, because I am about to come on and say that use of 9.2b is extremely difficult in the biometric space. But and actually, I will move on to that now. The reason why we're talking about biometrics a couple of times there is biometrics and thumbprints probably a little bit outside the AI space in thumbprint recognition. There is still some automatic matching going on. But we've done a lot, obviously, in the facial recognition space where you have to have a face. It's a biometric system that then will process it and it will match your face and so on. So some of it is very relevant for AI. I mean, I'm going to start very simply from a European perspective. Obviously, am I doing that correctly? Yes, I am. There we go. Obviously, we're processing lots of personal data within this space. You know, machine learning might in itself, for the learning, have to be processing personal data. If it has to learn everyone's face here to make sure on an AFR system that it works, it's going to have to learn Marco's face, my face, Soren's face, and so on. And similarly, when it is actually doing the processing to check that it is Soren entering the building, there is processing there of personal data. So the ICO in its guidance on AI is very clear. It has lots of simple questions. Is data being used fairly, lawfully, and transparency? Do people understand how their data is being used? How is the data being kept secure? I don't think today we'll go into any detail there because we've done that in many other sessions. The 2 points I want to focus on are the special data issue and Article 22, just because I think they're probably the most interesting. So I've extracted onto the screen there, which I very rarely do during these sessions, but I thought I might as well. Article 9 in relation to special categories of data, just to pick up this example of biometric data. You can see there writ large in the middle, 9.1, biometric data for the purposes of uniquely identifying a natural person. There you go, it's biometric data. That's what Soren's talking about there in relation to thumbprints. That's what I was talking about in relation to automatic facial recognition. Now, 9.4, we have that there. You can introduce further conditions, including limitations with regard to processing of biometric data. So far, there aren't that many of them knocking around. They might appear in the future. But we have had so many issues with clients where their use of AI does involve biometric data. Quite regularly, we're asked by clients, can we use AFR, automatic facial recognition, within our CCTV operation for COVID? Marco, boom, he's got his temperature of 36, it pops up on the reception, it's Marco Sideri, employee number 11345. Or quite a few of our financial services clients say, we have very private areas where only certain people are allowed to go, and we must have advised on this 10 times. We want to use automatic facial recognition so that if Marco, I don't know why I keep picking on Marco, but he's not a naughty person, but he's just the first person I can see. We need to use AFR to make sure that if Marco crosses a threshold into the room he shouldn't, something will bleep and he will go and be grabbed by the security guards. And the problem is, no matter how laudable that all sounds, and it's all very interesting, it's a real struggle from an employment perspective to find your Article 9 condition, because consent is almost impossible in the employee sphere. So you're then looking at, can we squeeze it into public interest in 9.2G? Public interest is interpreted very narrowly, and especially very narrowly in the employment sphere. So then we start looking at, can we squeeze it into 9.2B, i.e. it's necessary for comply with the employment obligations. And fascinating to hear from Soren that in Denmark, in one case we could, but I have to say for everyone on the call, that is not necessarily the norm, okay? It is very unlikely, Soren, yes, go.
Well, actually, it wasn't squeezed under Article 9 of the GDPR, it was squeezed under Article 12 of the Danish law, which gives you a legal basis of processing if it follows from a collective bargaining agreement. And that was why they had a legal basis of processing. So you have that catch. It's the exact same in Denmark. If it's Article 9, it's extremely hard to use it.
Right, thank you, Sarah. So for those of you thinking, and we have had this because lots of people are planning new office moves now, let's put in place an AFR system, let's put in place some cool biometric lifts, thumbprint lifts. It's actually very difficult to do that. And this applies to any elements of special data that you might be using AI. Let's say that you have a diversity and inclusion protocol, quite rare across Europe, slightly more common in the UK, where you might be exercising some element of quotas or positive, not positive discrimination, but positive application discrimination in relation to certain ethnic minorities or certain sexual orientations or so on. And you have a system which tries to ascertain whether someone is of X, Y, and Z race or ethnicity for the purposes of recruitment. Again, you are processing special data there. It is not going to, you're going to come a cropper, no matter how much you do in terms of a DPIA, no matter how much you think it's going to happen, there are going to be these barriers from an actual technical processing perspective. I'm conscious of time, so I'm going to go on to the next interesting point. And in fact, someone's mentioned it already. I think it might have been Marco or Jose. But Article 22 is also relevant. Now, Article 22 does not need to engage special data, okay? If you are just processing basic name data, the most vanilla data you could imagine, the data subject still shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects or similarly significant effects. So you can imagine you have to analyze, are we caught by Article 22 each time? Because you have to analyze, is the processing based on automated means? Does it produce significant legal effects? Or if not, what is the boundary and threshold of similarly significant effects? Because various DPAs around Europe have different views on that. And it's very important because if you are caught by Article 22, not only under the transparency modalities in Article 13 and 14, you have to provide additional information, you also have to look at 22.2. Paragraph, it is prohibited, okay? You cannot do it unless it's necessary for entering into a performance of a contract between the data subject and the data controller, it's either authorized, which is very limited, or it's based on a data subject's explicit consent. So come back to the workplace context again, based on a data subject's explicit consent. That is really very difficult in the workplace context. So we tend to then have to look at 22.2a, is it necessary for the performance of a contract? But necessary is a qualitative concept. It's very difficult to analyze. Someone's necessary is probably a regulator's unnecessary. We do need to be realistic here. So in fact, we need to look more at, can we intervene with the human element into our decision making? So you can have a wonderful recruitment system that discounts Marco because it's called Marco. Again, I picked on Marco, I'm sorry. But as long as the final decision is taken by a human who goes, okay, that's a good decision, no Marco, then you can be out of Article 22. But that, of course, can render some of these systems inefficient or inefficient. And of course, a lot of this work is designed to promote efficiency. So similarly, you can do your analysis saying that because Marco is going to be paid a little bit less, only a couple of quid more, less a year, it's not a significant effect on him. And you can try to make that argument. But you better have done a DPIA explaining your conclusions, because if the Works Council or an employee or the regulator comes looking and you haven't analysed your position, you haven't written it down on paper, you might be in trouble. So, real whistle stop there. And I think, Anastasia, you're probably going to have a couple of minutes extra on just some Russian nuances.
Yeah, Alex, thank you. Actually, I would like to talk about differences in processing of biometric data in Russia. Actually, it is allowed to process biometric data, including by means of facial recognition, if it is done to protect state interests, safety, and health of individuals. But this is allowed to the state and some organizations who have the contract with the state and state authorities. But this is not available for employers, for private companies. And private companies have to rely on a general legitimate basis, which is usually consent. So actually processing of employee biometric data, if it is processed for identification purposes, requires written explicit consent of employee. And we have a very noticeable case when Russian court confirmed that the face picture on the access badge was regarded as employee biometric data, and it was stated that the consent is needed for such processing because it was on the access badge, and therefore it used for identification of particular subject who entered the building. So it's quite complicated in Russia, not only in terms of automated decision making, but also in terms of processing of biometric data, as employers have to obtain this written consents or just refuse from these technologies.
Thanks very much, Anastasia. Just one 15-second question. In Europe, there's guidance from local regulators and from the EDPB that consent, normal consent, certainly not explicit consent as well, is almost impossible in a workplace context, except in some examples. But is it possible in Russia then to get consent? Is it just require someone to go yes? And is that consent, or can that consent then be challenged later?
Consent actually can be challenged later if it was obtained in violation of requirements to this consent. So when we are talking about processing of biometric data or automated decision making, the consent must be written. And in Russia, written consent means that it must contain various information, including ID information of the employee. And it must provide, it's like a very long privacy notice, but also including ID data of the employee. And in case further employee states that some information was not provided to him or her, so the consent can be changed.
Okay, thank you. I mean, obviously, and as everyone knows, I'm sure on the call, we could do all of that in the UK and across Europe, and consent still wouldn't be valid. And Jessica, I'm going to come to you just for a couple of minutes on the second speed dating session, which is going to be Jessica and Jose. Which my slides, honestly, there we go. Very slow. We're going to talk just about Works Council developments, I think, in Germany, and some interesting comments that you raised earlier about Works Councils. Then Jos is going to give a bit more color on some developments in Spain. So Jessica.
Thanks, Alex. Yeah, maybe one clarification to start with. There is no obligation for German employees to elect a Works Council. So typically in a small company with, let's say, 10 to 20, 50, sometimes even 100 or more employees, you don't necessarily have a Works Council. But of course, all our larger clients, they all have a Works Council. So once there is a Works Council, anything which can be used, and it's enough that it can be used, there must not even be an intention to monitor employee behavior or performance, must be agreed upon with the Works Council in advance. This means it must be presented, it must be explained. And Alex, you mentioned the recommendation to do a DPIA. This is something which is certainly advisable if it is a more complicated or intrusive system. And I also agree with, I think you mentioned it earlier, and also Marco, systems are just getting more complicated. So it's really difficult to get to the bottom of that system and to really understand. So this is sometimes part of the process. And of course, the employer side is they are often under international pressure. If it's an international group, they are Germany and France are usually the latest because of this co-determination process. At least that's what my observation is. And yeah, it can take a while to really present the system, to negotiate the rules, and finally to come to an agreement on on anything that can be used for monitoring, and of course anything which is artificial intelligence used at the workplace it ticks one of those boxes. Yeah, thank you.
Thanks very much, Jessica. And Jose, just a little bit more color on Spain as well. Thank you.
Okay, thank you, Alex. Yeah, last week, May 12th, a new Royal Decree 9.2021 was published. And that changed one article of our statutory law called Estatuto de los Trabajadores 64.4, which establishes in the discussion, in the clash between trade unions and employers' organization during all these months, debating whether or not riders should be recognized as employers or self-employees. This act, or this Royal Decree, was approved, was published with two elements. One is the presumption, juris tantum. That means proof can be bring it and can prove the other ways. I mean, otherwise it could be a different thing. Means that riders using digital platforms by means of algorithm management will be considered as employees unless employers proves otherwise that they are self-employees. So Deliverers, Globos, etc., these kind of companies, they have this presumption. But the second thing, and here's the, related to this presentation, is there is a new right in Article 64.4, which in favor of Works Council, they have the right to be informed about criteria, rules, and instructions upon which algorithms or AI, artificial intelligence systems, are used when taking these managerial decisions about the working conditions, access, and keeping the job place, including also setting up of profiles. So it goes without saying that this new right, it is or derives directly from Article 22 of GDPR, which prevents, as we know, that an individual may be affected by a decision taken only by the automatized personal data. The bottom line of this is to provide a first warranty against this idea and preserves the idea, as you were mentioning, Alex, that the idea of the human control over the system. Because since we don't know if the data controller, the employee that has been allocated or responsible in the company when treating such data will be capable or not to challenge the decision of the algorithm and then prove that there is a human control over the system, the law permits the Works Council or representatives to get such information. This trend is quite interesting. We're going to see how this evolves. But this is also important in the context of collective bargaining agreements. Why I'm telling you this? Because, for instance, in the banking sector and others, they are including rights before artificial intelligence as a way to defend employees against this new kind of elements. That obviously, as I foresee, there will be an update of the content of these articles when it comes to digital labor environment, and also will obviously empower trade unions to get information and bargaining with employers to be more transparent, respecting the principle of transparency, and about the AI system and algorithms that are used, avoiding biases, and obviously discriminatory results in the decision-making process and reviewing obviously the accuracy and the reliability of the algorithm that is being used. But then here's the debate. This is one thing, but there are a lot of, I mean, this is just an article, and there are many things, types of things that remain absolutely unclear. On the employer side, the main interest obviously is to preserve the algorithm, has paid for that obviously, as a trade secret. So this is something that really is the gist of the activity, the sense of the activity. And then obviously we foresee, as a reminder, that we foresee certain, obviously logic resistant, I mean, it's going to be absolutely reluctant to disclose information about how the AI system works. Although there is this article you were mentioning, Alex, 14 of GDPR points out the employee's right to know about the existence of this automatized decision. Well, sorry for this quite long explanation, but
that's wonderful. Thank you. And in fact, I've had many discussions with many clients about their desire to maintain confidentiality in their own designed algorithms that are proprietary and possibly give them a competitive advantage against others, versus balancing that against disclosure under GDPR rules. We're just going to come on to what does the future hold. In fact, and I'm just going to cut off these slides actually because they have no relevance as yet. But Soren's going to just give a couple of minutes on the AI regulation, and we'll come back to Marco for a final thought. But just my thoughts, ICO has lots of guidance on this. You know, Elizabeth Denham herself says that the innovation opportunities and potential value to society of AI will not need emphasizing to anyone. But then she emphasizes the risks and asks companies to make sure that they do their DPIs, they work through this properly, they use the ICO sandbox. And I would recommend anyone on this call has a look, just type into Google ICO sandbox and read some of the exit reports from the companies that have entered into that sandbox. I'll pick two now. Heathrow exited the sandbox in 2020. They were testing their automation of the passenger journey, AFR. So you don't have to show any documents bar one time when you get into the airport. And when you go to UK airports now, you will see these facial recognition gates that, if anyone goes to any airports at any point at present. But that is quite a fascinating read. The second one is on Fido that exited the sandbox in November. And they have worked in that sandbox specifically to identify and mitigate bias in their biometric verification technology. So we've mentioned biases a few times across this piece, but it should be very obvious to everyone that if you are using an AI system that has biases within it, you are going to be committing various unlawful discriminatory acts within the employment sphere. So bias is a crucial thing. And so that on Fido report is, I won't say it's a cracking read. It's a cracking read if you're a data lawyer, but it is worth a read if you're thinking of entering into that space. And that brings me on to Soren, who's going to go through the AI regulation in a couple of minutes only before we go over to Marco. And I'll just add my final comment. Just said the UK's approach has been very much about being pragmatic, open, reasonable, proportionate, but leaving some autonomy with the data controllers. The proposal for the AI regulation is slightly different from the European Commission, and I'll just hand over to Soren for, say, 3 minutes.
Thank you, Alex. I think what I'll say initially, or as a starting point, is that before talking about the rules and the prohibitions, one should realize that the idea from the Commission is to create ethical rules, global norms, so AI can be trusted, not to ban AI. The idea is still that Europe should be competitive. and we should just have some ethical rules. And that is probably, obviously that's a politician saying that, and they could have other ideas lying underneath. But generally the idea is that we should have some ethical rules so we can use the system. But if you then broadly, just for a couple of minutes, look at the rules, the suggestion is that you will divide it into 4 types of categories. One being AI that creates an unacceptable risk. The second being the type of AI that creates a high risk. Then you have a low risk as the third, and the fourth is a minimal risk. What creates an unacceptable risk is essentially things about the safe and healthy and fundamental right of natural persons. That is going to be banned under the suggested regulation. What is interesting here for employers is what the high risk suggestions, because that's where you will have a sorting of CVs, software for recruitment procedures and employment matters, work management regulations. So that'll be considered high risk, which does not have a prohibition against processing it, but will have strict obligations before you can use it or before it can be put on the market. So that is what employers are looking into, that you will probably have a lot of requirements. Formal requirements have to be met, disclosures, so on and so forth, in order to use it in employment law matters. But if you meet those requirements, hopefully, and if they stick to what they said, the idea is that you should still be able to use it. If you then look further into it, because that's obviously always the interesting thing when EU introduces new regulation, is what is the downside, what is the penalty if you contravene or if you break the rules. And it is going to be not quite what we know from the GDPR, but so far you're talking about fines up to 30 million euros or 6% of the turnover. It depends on the category. Then you have one category which 20 million euros, 4% of the turnover. That's the worldwide turnover. But what is also interesting, and what we talked about, is that one of the things you're going to look into under the suggested regulation is whether another administrative fine has already applied by another authority for the same operator for the same infringement. Obviously, because you're going to have a very close relation to the GDPR, so you can end in a situation where you will get fined multiple times, but then it should be taken into consideration whether you already received one fine. So it is interesting times. Obviously, this is just a very new, less than a month old suggestion of a regulation. It will be years before it's implemented, but I have no doubts that it's coming. I have no doubts that when we have this seminar in 5 years, we will instead talk about what exactly we can process, what we'll have a legal basis for, and what we won't have a legal basis for.
Yeah, thank you, sir. And that was a very good summary in 3 minutes. Thank you. And I do find it strange that the fine profile is now 6%. For it is quite bizarre. I wonder whether that's a typo, but it can't be, because it's obviously 30 million up. Marco, should we just have 2 minutes from you on something exciting? And then I will hand back over to Annie to wrap up. And thank you, everyone. If I don't get to say thank you, so thank you to the panelists as well. Very, very interesting.
Thanks very much. Just 2 minutes, because there's so much that came up during all your talks, and 2 minutes, not 2 hours, are enough. So let's just say that we all agree on the scenario, which for a lawyer, of course, is a terrifying perspective, because agreement is the last thing that we want. But we all agree that artificial intelligence is coming, and we all agree that we need to use it in a good way. And we all agree we do not want to be ruled by evil robots, because then, you know, discussing these things, even from a technical point of view, you're always a step away from evil robots governing the earth, because again, we don't know. What we can add to it as lawyers is A, try to get to the bottom of it as far as policies go, but do something. Not doing something is wrong for fighting robots and fighting claims. So just do something, see what data you have inside you, see how they can be explained. Another thing, and that's more lawyerly, and I'll close on a lawyerly note, that needs to be taken into account is what are the claims that may be coming and from whom, and what's the burden of proof for these claims. We've seen, and the second example Alex gave on cases is very interesting, that sometimes authorities go beyond what is agreed between the parties, even social parties and even the unions. So we have a multiplayer game here, authorities, state authorities, EU authorities, unions, and individual bringing claims, damages claim. That's an interesting topic for a future seminar. Data privacy, not fines, but damages claims. They're coming, they're wobbly at the moment, at least in Italy, because they're evil robots claim, you know, I'm so sad I was spied upon, but they're coming and there's so much to say. So be calm and try to see what data you store and how to tell them. And thanks everybody for this hour.
Yeah, thank you, Mark. And I'm going to hand back over to Annie because I know we're just over time, but we will be touching on we're going to talk about enforcement and fines in the next session, but I will also talk about some of the UK decisions around damages, because we're also going to have the Lloyd versus Google Supreme Court decision possibly before the next session. So class actions in the UK around data are a new thing. We're ahead of Europe, continental Europe in some ways, behind America. I will pass over to you, Annie, and I will share that screen because I know that is what I'm supposed to do. But to everyone, I thank you and have a good afternoon.
Thanks, Alex. Yeah, I'm already sharing from my side. So thank you, Alex, and all the other panelists. We've now finished the session for today. But if you're still interested in reading more about data privacy related issues, I advise you to check out our insights page on our website. You can find several interesting resources and articles on those topics. And then for more information on the Use Labor's webinars and podcasts, you can visit our event section on the website again, where we keep all the past recordings, also the one from today. And as a reminder, these slides you can also find on the website. So finally, also from my side, thank you everyone for attending today, and thanks also to our amazing panelists. So with that, this webinar will now be ending. Thank you.